There are certain safe harbor provisions in U.S. federal law that can provide protection against money laundering charges for specific entities, such as financial institutions, and their employees. These provisions encourage reporting of suspicious activities and cooperation with law enforcement. One key safe harbor provision can be found in the Bank Secrecy Act. This provision protects financial institutions and their employees from civil liability for filing suspicious activity reports, SARs, in good faith. A SAR is a report filed with the Financial Crimes Enforcement Network, FinCEN, when a financial institution detects a known or suspected violation of federal law, a suspicious transaction related to money laundering activity, or a violation of the BSA. By filing a SAR, financial institutions and their employees can avoid potential liability for facilitating or failing to report suspected money laundering activities. Another safe harbor provision can be found in the U.S.A. Patriot Act. This provision exempts certain persons or entities, such as licensed banks, credit unions, and registered brokers or dealers, from prosecution under the statute for operating an unlicensed money transmitting business, provided that they are in compliance with applicable federal and state registration and reporting requirements. Additionally, the Money Laundering Suppression Act of 1994 amends 18 U.S.C. Section 1956 to provide a safe harbor for financial institutions that report potential money laundering violations to the appropriate federal authorities. This provision ensures that financial institutions will not be prosecuted for money laundering when they act in good faith and promptly report suspicious transactions. These safe harbor provisions can offer protection against money laundering charges for financial institutions and their employees who comply with reporting and regulatory requirements. However, it is important to note that these safe harbor provisions do not provide blanket immunity for all money laundering related activities. In order to benefit from the safe harbor provisions, financial institutions and their employees must act in good faith and comply with all applicable reporting and regulatory requirements. In order to benefit from the safe harbor provisions, financial institutions and their employees must act in good faith and comply with all applicable reporting and regulatory requirements. As a federal criminal defense attorney, it is crucial to be familiar with the safe harbor provisions and to advise clients on the steps they can take to comply with these provisions and avoid potential liability for money laundering.